Bringing the judge now, Andrew Napolitano, our Fox News senior judicial analyst. Sir, good morning to you.
Hello, Bill.
Initial reaction from you is what?
That the heart and soul of the Arizona statute has been struck down by the Supreme Court, consistent with previous Supreme Court opinions that basically say, for better or for worse, whether you like it or not, immigration is a federal issue to be administered by the United States of America, by the federal government, and not by the states, so that immigration law means the same thing in all 50 states as it does in Washington, D.C. Basically, the court is saying to those in Arizona who are understandably unhappy with the administration of immigration law by this administration, if you don't like it, vote them out of office, but don't try to change the law because you are essentially without authority or sovereignty to do that.
One part of the law that stands, though, Judge, if the officer reasonably suspects the person is in the United States illegally during an individual stop or detainment, that apparently still stands. And the point that Shannon Bream makes there is that now you're going to see when an officer does this, what sort of a court challenge comes from that?
You're probably going to see a court challenge the first time the officer does this. Because
in all likelihood, you're right. But based on what we've heard from the court today, does something like that stand or not?
Well, it's unclear from reading the opinion. It's about 125 pages, Bill. It's been out for about 15 minutes. It's unclear from reading it if the Ninth Circuit injunction, that's the order issued by the Court of Appeals preventing Arizona from even engaging in this, look up on a computer and see if the person is wanted by the federal authorities for a violation of immigration law, still stands. In other words, will the law, is that Section 2B automatically undone? I suspect that the Supreme Court is looking for a factual challenge in which a state court can decide whether or not the police are appropriately exercising this authority under Arizona law. Because if you look at it in a very narrow way, the state of Arizona basically said to police officers, when you stop somebody, see if they're wanted for other violations of law. You automatically do that. Now you can see whether or not they are wanted by immigration authorities. The see if they are wanted is an internal police function, and the Supreme Court wants to see how that works out. The stop them because they look like they're illegal immigrants is what the Supreme Court put a stop to.
All right, but the court did say part of the law requiring police to check the status of someone they suspect is not in the U.S. illegally could go forward. And now we wait to see whether or not that has another legal challenge.
That means that probably this afternoon in Arizona, someone will be stopped for
maybe by 12 noon Arizona time.
Someone will be stopped for jaywalking with DWI.
There are numerous states that are still going through their own definition of this law. Alabama, you think about Georgia, there was a challenge in Indiana, South Carolina. Does any of this today affect those laws in other states?
Yes. This opinion strikes at the heart of the Alabama statute. I'm unfamiliar with the one in Georgia, but I've read the one in Alabama. Both the Arizona and the Alabama statute presumed that where the federal government chooses not to enforce federal immigration law, the states may stand in the place of the federal government and enforce the federal law as they, the states, understand it to be. Today, the Supreme Court has said the states may not do that. No matter how well-intended their motives may be, no matter how burdensome is the problem with illegal immigration in their states, only the federal government can enforce in a traditional way federal immigration law.
A quick and pointed question. How is Alabama different from Arizona? Or are you arguing that that doesn't even matter now?
I don't think it matters after reading this opinion, because the linchpin of what Alabama and Arizona did was the same. We're going to stand in the shoes of the feds because they're not doing their job. The Supreme Court has said definitively, with respect to immigration, the states may not do that.
Judge, the decision is by Justice Kennedy. Does that mean anything?
Maybe he's having a busy week, Jamie. I don't know.
Well, he's traditionally the swing.
He is the swing vote between the 4 liberal justices and the 4 conservative ones. We, of course, are all waiting, and I detect this in your wonderfully delicious question, Jamie. We're wondering if he's going to be the author of the Affordable Health Care Act law or opinion, which will probably come down Thursday. If he is, he's having a very busy week.
All right, Judge, don't leave town, all right?